the Attorney General is at the Supreme Court asking the court to answer a number of questions. And it's on the back of these reliefs that the former Chief Justice is seeking in her latest application that we discussed last week, that there should be a declaration that the President is devoid of power to remove a Justice of the Superior Court from office without recourse to the mandatory procedure set out in Article 146. And this, a declaration that jurisdiction to hear a petition for the removal of a Justice of the Superior Court from office lies with a body properly so constituted under Article 1464 of the 1992 Constitution. And this is the crux of the issues, the questions that the Attorney General is asking the Supreme Court to answer. The former Chief Justice is seeking a declaration that the warrant of removal executed by the President dated 1st September 2025 purporting to remove her from both the office of Chief Justice and the office of a Justice of the Superior Court of Judicature is unlawful, null, void, and of no effect. And so the Attorney General is at the Supreme Court asking a number of questions. One, that whether a person may retain his or her previous judicial office, if any, upon appointment to the office of the Chief Justice. And two, whether the Chief Justice's membership of the Superior Court of Judicature is ex officio to the office of the Chief Justice. And finally, whether a person may retain his or her membership of the Superior Court of Judicature upon removal from the office of the Chief Justice. Now, this is why the Attorney General is at the Supreme Court. Will this move or decision by the Attorney General to seek this particular intervention or interpretation by the Superior Courts, that's the Supreme Court, bring some finality to the matters at play?
First of all, there's an inherent incompetence in the judicial review application that has been filed. When you go for judicial review, you are inviting the court to exercise what we call supervisory jurisdiction of the court. You cannot, in invoking supervisory jurisdiction, ask for what we call declarative reliefs. So the declarations that they are seeking within the context of a judicial review application is incompetent. The Constitution is clear as to what powers can be exercised. So if you go to Article 161, I would read, it gives you 1, habeas corpus, certiorari, mandamus, prohibition, quo warranto. Those are the only reliefs you can seek. So declarative reliefs are not one of them. Secondly, legally, and this is the confusion that I've seen so many people make in some of this discussion, it is presumed that the Chief Justice is at the same time a Chief Justice and then a Justice of the Supreme Court. She's not. Those are different offices. The Chief Justice position is a fresh appointment. It's not an elevation. A person can be appointed from the High Court to become a Chief Justice. So that when you say that the person is then removed as Chief Justice, the person should go back to the High Court. That's what they are suggesting. Once you are appointed to the office of the Chief Justice, every previous appointment you have held has ceased. You no longer exist as another additional judicial officer.
So it's not a position that you hold in two.
No, you don't hold two positions at the same time. And I've seen this being spoken about, like so many confusions. No. And when a justice is appointed, when Justice Gewu was appointed from the High Court to the Supreme Court, he didn't at the same time hold the High Court position together with the Supreme Court position. It's extinguished, dead, gone. So in the case of, former Chief Justice Torkornoo, she was a Supreme Court justice, and then when that ended, when she was appointed, by going through parliamentary vetting and that becoming ratified, she then assumed a new office. So she only exists as Chief Justice. Having been removed as Chief Justice then that's it. You don't go back and say that the previous office I held before I became a Chief Justice must be reinstated. There's nothing to reinstate. So that's the confusion here. I'm very happy that the Attorney General has decided that he will take this matter to the Supreme Court. Because there's also some confusion that people were suggesting that this is settled matter. But it's an inherent confusion where people think that an obiter reasoning of the court, when you say obiter, things that the judges say along the way is the ratio or the main reason. If I go to court for to ask the court whether, the fact that this process was publicized would invalidate the process. There's a specific question that the court is answering. Even in terms of talking, the judge says, and I also think that once you are removed as Chief Justice, you have also been removed as Supreme Court Justice. It is not what the court was deciding. It was something they said by the way. So perhaps for us to get complete clarity on this, we have to understand how law functions. A new appointment is made when the person is appointed as Chief Justice. The person can accept or decline that job as Chief Justice. It's not an add-on to their role. It's a role in itself. So when you look at the constitutional structure, it says that the Supreme Court is made up of the Chief Justice and the Justices of the Supreme Court. So these are separate. It doesn't say that it's made up of Justices of the Supreme Court, one of whom has an additional responsibility as. No. It's a different office on its own. And you see that the Chief Justice then, by reason of Chief Justice, is part of the High Court, is part of the Court of Appeal, is part of the Regional Tribunal. All different sectors of the court system. So when that office then, you have been removed from the office, your ability to belong to the Supreme Court, your ability to belong to the Court of Appeal, the High Court, and the Regional Tribunals is all gone. So that's for me at least, that's the reasoning I take in terms of how we understand the structure that the Constitution has created around this issue.
I say that as for the Obita debate, I think we settled it last week on this same platform. So there isn't much to. But then again, you mentioned that this move of judicial review, in your view, based on at least the references of the law that you indicate, the Attorney General's decision to seek interpretation will bring some finality to this. Is it on the same part?
Absolutely. Look, there was a release from her camp, and one portion struck me, and I think I just want to read it. It's very short. It says, if someone wants to destroy the work of a judge of significant repute of many decades and her accomplishments, the least that should be done in a constitutional republic is to at least accord her the basic rights she is entitled to as a citizen. She has a right to know the findings against her and the reasons for her removal in a proper written and complete report, so she can avail herself of any remedies available. The point here is it possible that the Chief Justice has been removed and she doesn't have a written report of the reasons why she was removed?
Is that the case?
That is the question. Okay, because I am told that she didn't get a report to the prima facie case, so she couldn't properly, if she doesn't get it, she can't prepare her defense. She's entitled to that. She didn't get a written report of the reasons why she's removed. These are fundamental. And so that's why I read. If it is true, and I'm reading from what Honorable Ayikweutu published, please get it and check.
He sent that to me.
Good, so check. Is that true? If it is true, then we are making a bad mistake. And you see, that's why I say, if the new CJ Bafoboni, after all his work, is going to ascend onto this seat, let it not go under this cloud. That you remove, you understand what I'm saying? Can it be that you didn't give her the prima facie report, that you haven't given her a report of why she's been removed? Now, the arguments that Oliver has just made, they are arguments. And like you said the last time, we had all kinds of arguments. I made a point here the last time that this table is not the Chief Justice, it's not the Supreme Court. So let that matter go before the justices, the lords of law, and let them determine it, because there is merit to it. So when you add the fact that...
So I thought you said there were precedents.
We argued the precedents last week. Yes. So for instance, so we've argued it. There were orbiters, and then Martin was able to show that Modibo actually spoke to it as a substantive issue. I was able to show that Article 146 Clause 2 says something which is directly opposite what Modibo said. So in law, we have something called per incuriam, where a judge makes a ruling that is directly in aberration with the law. So the issues are clearly there. Now, seeing that she has a cause, and she has not exhausted the legal remedies available to her. And somewhere also I read something which is very important. It said, this is the Chief Justice. If anybody has a moral responsibility to fight for what is right procedure, it is her. you have a situation where people say, oh, they've removed her, she should just go home. No, I said last week and I repeat, this fight is useful for us more than her. But for whatever it's worth, this is a career, an illustrious career. You don't just get up and throw it into the dustbin. Give the woman at least what she is justly entitled to and let her go through the processes and fight a case. There are about, I hear 4 cases pending on this matter. Yeah. The determination of which can move this here, there. People think she's trying to come back as Chief Justice. I don't see how that is possible. All right? Okay. But the truth is that if there are 4 cases pending, look, Oliver, for instance, sued on these people who were, deported here. All of a sudden, I heard that they have been sent back. If there's a matter in court, and the matter hasn't been determined, and I don't know the facts, so you can tell me, but if it was in court, hasn't been determined, we haven't had finality and a judicial pronouncement of it, and then the executive just goes ahead and overreaches the matter, it is wrong. And that's why we should
asked
be
the
careful.
same question. The answer was that there was a process in motion, so it wasn't as though they were going to stay here.
But a judicial process holds things. He has the facts, so he can correct me on that. But where I'm going is that when somebody has a matter before a court, you hold your hand. And in the situation where this has to do with the courts themselves, a Chief Justice, it is a bit worrying to me that it's almost, ignored that she has matters in court. Again, we keep going back to the Demolovo case. We have a matter in court for 2 years, it's not heard, and then when it comes, we win the case, but then it's already moot. Okay, it is worrying. It is worrying, and I think we should do something about it. If you read the statement that they put out, okay, it casts a shade, and I think we should get rid of these things and then move forward with a clear mind.
I acknowledge what Nia Iko to the lead counsel for the former Chief Justice Torkornoo has sent me. In fact, portions of which you have referenced. Yes. So I have that statement from Nia Iko to he sent that to me as well. People, this
maybe you should put him on the line.
Yeah, this decision, because of time, but this decision to seek this interpretation, the questions that the Attorney General is asking of the Supreme Court, would it settle the issues that Kofi Bento, for instance, raises, and what the counsel for the former Chief Justice is raising, specific to the entire process of whether or not she can still, or the warrant of removal affects both portfolios as a Justice of the Superior Court and a Chief Justice?
Yeah, okay. As for the removal affecting both, there is no doubt at all that it does. That one, there is no doubt. And that resolves most of the issues that have been raised. Because, you see, last week we refer and we repeat. The Supreme Court said in the Agyapong case that when you are removed as a Chief Justice, by implication, you are removed as a Supreme Court judge. That's page 804. We read it.
Yes.
Modibo saying it. And then you come to Datiban also making the point. Look, before Datiban made the point that your actions as a Chief Justice affect your actions too as a Supreme Court judge, what he first did was to pull out arguments that the plaintiff had made. And it was the plaintiff who argued that when you are removed as a Chief Justice, you are removed as a Supreme Court judge. It was the plaintiff. Let's read it for emphasis. So, Oliver, sorry, I have to...
You are re-arguing last week.
Yes, because that's what it involves. Oliver, I don't know if you paid attention to this. He said, and by all means, it's not possible that...
Order 55?
Sorry, no, the point that the remover, you're saying that when it's obiter, and I'm saying no.
Okay.
At 2 points, I don't agree.
Okay.
Look, this is page, if you go 773, okay, you see that Datiban, he quoted verbatim the arguments that Agyapong made through Bediatuo and his father, right? He says, paragraph 12 says, the Constitution does not provide any separate and distinct grounds other than those set out in Article 146, Clause 1, for removing the Chief Justice, Chief Justice from office. Thus, under the Constitution, a Chief Justice cannot be removed as Chief Justice from office and remain on the bench as a Superior Court judge or as a Justice of the Superior Court. Let's repeat. It was Agyapong who argued that, thus, under the Constitution, a Chief Justice cannot be removed as a Chief Justice from office and remain on the bench as a Justice of the Superior Court. That's paragraph 12, page 773, 774. So you see that the Supreme Court copied out their arguments and set out to answer. And Dateba said, look, your actions as a Chief Justice also affect your actions as a Supreme Court judge because of the ethics. I mean, we can read out that. So, Oliver, the point where you said that for you, when somebody is appointed as a Chief Justice, the office of Supreme Court judge is gone. That one, respectfully, I disagree. That's not how. No, because they say that you are a Chief Justice. Your actions as a Chief Justice also affect your ethics as a Supreme Court judge. Presumably, that Supreme Court judge office is still there.
So any act that breaches the ethics in your capacity as a Supreme Court judge also affects that capacity as a Justice of the Superior Court.
Excellent. Yes, that's what the Supreme Court
they are two separate,
said.
and the removal process should be different.
No,
But my issue is the procedure now.
All right.
My issue is the procedure now. Was she giving the reports?
Yes.
Yes.
That's a key issue.
So when it comes to that, let's read. Then Modibo said the Chief Justice, upon his removal, will by implication also lose his position as a judge. The Chief Justice, upon his removal, will by implication also lose his position as a judge. That's Modibo Okran at page 804. That's Justice Modibo Okran.
We'll put that on the
and
screen
before
right
he
now.
did so, this is what he says. He says, however, an interesting inferential question arises. Since the grounds for the removal of the Chief Justice are placed at par with the removal of the other justices of the Superior Court, can the Chief Justice continue to sit as an ordinary member of the Supreme Court after being removed as a Chief Justice?
There's an error there.
Suppose
it's not at par. That's where the error is.
Oh,
there
well,
are two different processes.
Well,
two different processes. It's in 1462.
Yeah,
that's what I'm saying. It's time Korea.
Suppose he or she was
resolve this
removed
matter
due to incompetence as an
It's a
administrator.
very different process.
But the person had a track record as a superb judge before being elevated to the position of Chief Justice.
A Chief Justice is not an administrative office. It's a
Let us
judicial
say
office.
that he or she was simply a terrible administrator. Why cannot such a person come back to his regular Supreme Court position and continue with his outstanding judicial performance?
So the premise is wrong. Martin, if a member of the bar is appointed as a Chief Justice, can the person sit on the Supreme Court?
Absolutely.
Yes, so the inherent in the Chief Justice is a judicial and administrative office. It's not separate. So it's not an administrative role alone.
Thing.
From because the argument.
Same thing. They're saying that.
Yeah, but you are saying that.
Is different.
Okay. That's what I'm saying. That a person is not removed. If you are removed as Chief Justice, you are removed in the administrative and judicial role. Not separate. That we should finish that one and come and remove you again as a judge.
Yes.
That's not. It can't be the case.
Exactly.
So they are separate offices. Once you are appointed to the Chief Justice, if you whatever you were before, you're no longer.
I'm not, but that
what you're saying doesn't work.
Yes,
if they are separate offices,
yes,
and there are separate provisions made for them. Okay,
if they're separate offices, if the Chief Justice occupying two offices at the same time, no,
give me 1 minute.
Okay, let me finish 1 minute. I don't need more than that. Oliver, your answer is here. Look, Article 128 Clause 1 says, the Supreme Court shall consist of the Chief Justice and not less than 9 other. Oliver, other. So it tells you
the question is not that. The question is whether the Chief Justice is both the Justice of the Supreme Court and the Chief Justice. It can only be one.
In a minute. Martin says one thing, and that is the same thing. Oliver is saying they are two separate. And I'm saying the two of them cannot be correct at the same time. That is one. I am making a third position. The third position I'm making is that look at the law. Article 146 subclause 2 says that as Justice of the Supreme Court may only be removed. It restricts you. Now, appointments for those two offices are different. Vetting for those 2 offices are different, and then removal for those 2 offices are differently provided for. The constitution of the committee are different.
Okay.
What it tells you is that they are different and should be treated differently. But look,
thank you. Prof, I think
we have a problem.
Okay,
let the Supreme Court deal with it.
I've been listening to Kofi Bencho on this matter, and I've been listening to Martin Pebu, and clearly, and I've heard Oliver. They are contrasting and conflicting positions on this matter. And I think that the way and manner, then some people also go out of their way to say that this current government means harm, and that's how come they are not listening to some of the things that are being said. I mean, it's problematic because if it were the case, then the Attorney General would not have gone to the Supreme Court to seek interpretation, to bring clarity. And so, for me, it tells me that the processes have been resorted to. The outcome has led to some more conflicting views about it, and it's important that the matter is sent to the Supreme Court for interpretation, so that there will be clarity. And so, to the extent that the Attorney General has not said that, look, go to hell, we are done with you, but is going to court to still find out whether being removed as a CJ, you can come back to serve as a judge of the Supreme Court. I mean, some of the things we look at law, but my own lawyer, who is a friend of mine, Genia, but a friend Gary Nimako, told me that law is also 70% common sense and 30%, practice. So I'm just asking myself that after ascending to that higher position and being removed, are you able to really come and function also as a common, justice of the Supreme Court? Okay, would that be commonsensical and all that? So my point is that it is important that we have finality, on this matter, and I like it that it's been sent to the same Supreme Court. Let us see how they rule, and let us hope
on the report.
Right.
Which report? That she has not been given. Okay. The report.
No. The fact, I agree with you that you see the decision, the processes have been resorted to, and I think that if there are minor procedural issues that can be addressed, it is important that they get addressed. Because, like you said, it is not the case that she's going to be able to overturn anything.
Thank you. Thank you very much.
And I said, he's the man for the job because, and I'm sure Prof had earlier on made the point, I think some months ago, about seniority, right? So on the Supreme Court bench, Bafuboni is the most senior. Even though Justice Amadou Tanko is senior at the bar, that's Amadou Tanko, and I think Mensa Bonsu. Yeah, they were called, yes. But in terms of the Supreme Court bench, Bafuboni is far senior to them because they came, was it sometime 2018 or 19, thereabout. Yeah, but Bafuboni has been on the bench from 1996 or 97. Yes. 96. Yeah, he started in the Circuit Court. Then in the year 2000, Rollins appointed him to the High Court. Then 2006, Akufo brought him to Court of Appeal. Then 2008, he made it to the Supreme Court, right? So I say that because he's the senior most, it's okay that it goes to him. And then more exciting is the fact that this is a Akufo appointee to the Supreme Court. And we all know we don't want to play ostrich with it. To get to the Supreme Court, you don't write an exams. It's political connection. That's the first thing.
It's competence. It's competence.
I know that's taken.
So do you put competence over whatever connection you talk about?
So first of all,
it's political connection.
It's political connection. That's what competence.
You are hoping that the president. Every appointment that is made by politicians, you are hoping that the president is competent. Please. But the criteria is that you have to be appointed.
I don't think that it will even be fair to the people.
That's the process we have designed.
Wait.
This is not a bad commentary on the people. The process we have designed is that you have to catch the eye of the executive. That's it. So if you're talking about reform, we can reform it, but that's it.
No, I'm not talking about. I'm not saying it doesn't play a role. Do you put competence or political connection over competence? so-called connections that you talk about.
Everybody is competent. So you see, the problem is that when I'm communicating, you know, we are very little. I don't know, maybe in a minute you'll stop me. So I go straight for the jugular, the most important thing. Because if I go and start from competence, integrity, by the time I'm coming to the most essential one, then you say no.
The perils of.
So I'm going for the most important. When I finish that and you give me more time, then I can go for the constant. So the constant is that he's been when I said he's been a judge since 1997, blah blah. I read all that. It's presumed that he's competent. That's why he's been there. If he wasn't competent, you'd have been removed a long time ago. So I don't waste any more time on the word competence. You see, so I go straight for the jugular. That is political connection. So the thing is that. So he had enough political connection for Akufo to take him to the Supreme Court. And that's 2008, right?
Yeah.
Now, how many years on? Almost 16 years on. President Mahama is making him Chief Justice. So the point I want to say is that political connection with Akufo means that he subscribes to the MPP ideology and philosophy. So for President Mahama to overlook Justice Puaman, who is Mahama's own appointee, it tells you that we've made a huge stride forward. It's huge progress because usually every president will want to appoint people who belong to their political persuasion. I mean the ideology. You see it? The ideology, the philosophy. So to see that Justice Puaman is on the Supreme Court bench, yet President Mahama went for Bafuboni, I think that yes, we should commend President Mahama for it. He didn't just say that, I'll look at my own appointee and give him the job. No. Says Bafuboni, yes, you are Akufo appointee, but you have the job because you are competent, you have this is the requisite integrity, etc. And most especially let's put another reason I'm excited that Bafuboni is made it is that, you know, during the Akufo Addo time, Akufo Addo ostracized and hounded Bafuboni ad nauseam, day in, day out. Bafuboni, they wanted him to resign, from what I've heard from certain sources. They wanted him to resign. Godfrey Dami was sent to go and broker a deal.
The sources told you that?
Yes. And you know, I've said it a number of times here. If it was false, I'm sure it would have taken me on. They were hounding him out of office because Bafuboni had the temerity to vote against Akufo Addo in the election 2012 petition. Okay. You know, the matter of the presiding officers who didn't sign the
signature.
If Bafuboni had voted for Akufo Addo, then it would have thrown the elections into a second round because all those constituencies, etc., they were to be nullified. You see, but because Bafuboni didn't vote for Akufo Addo on the bench at that time, when Akufo Addo took office, Akufo Addo never forgave Bafuboni for it. So they gave him hell. It was pathetic. Even Jubilee House, for most part, was a no-go area. He wasn't welcome to the Jubilee House, etc. It was so horrible. Why do you think Akufo Addo got that name, Nebuchadnezzar, etc.?
Is that to say that even though seniority is a big consideration at the bench, other elements could still water down that particular consideration of seniority?
Oh, absolutely.
The president can appoint anybody.
Anybody, just like, so let's go to Justice Torkornoo. At the time she was appointed, she had at least not less than 7 seniors ahead of her. I think some people say 11, but I'm just, I think I've heard 11. So Bafuboni is senior to her, right? On the Supreme Court bench, Puaman, Tanku, there's Avril Johnson,
Mariama,
Doji, of course, they have since retired, etc. There were a lot of seniors ahead of her, but she got the nod. Okay, so it's not, you won't find a straight textbook on it. It's a lot of horse trading, negotiations here and there, but key among them, usually, presidents are looking for loyalty. They want to go to bed, okay, a peace, or they sleep soundly, knowing that if a case comes to the Supreme Court, they will win. You know how politicians are. They don't want to be saddled with Supreme Court losses here and there. They like to win. You see how the Domlovo case, when we sued, Kofi Metal and I, we sued on behalf of CDD, etc., ASEP, and all the One Ghana movement, etc. You see how the case delayed. It delayed because
we were winning.
Yes. You see, even though at a point we also contributed, there was fatigue, you know, this up and down, where at a point we also were tired, you know, you get, but bottom line, when the court, the key things are if the court wants to move, it will move. If you don't bring your issues, the court can sit there and say, look, these are the issues we've identified. We are going ahead with judgment. You remember, when you want to see the speed, Oliver and Kofi is here, you were a lawyer in the Asian, what's his full name, the pink sheet case.
Yes,
that they send you into their own offices one day that produce the issues and then let's adjourn for judgment.
They reconstituted the court in a different room. The justices went and sat there. They summoned the lawyers. They put us in a room to rewrite and amend the LI.
So the
reason why pink sheets today had the main that case, and credit to my senior Sheshe for him, you know. And when the court wanted to take action, in fact, the Supreme Court chamber was under renovation or something. They moved it into a different place. They finished the case. They ordered us into a room. We sat there for hours, redid that rule, came back and adopted it. Otherwise, we wouldn't have had pink sheets. That election was going to go some other way. So if they want to do it, they will do it.
Yes, so that's the point. So that's to buttress the point that when the court wants to move swiftly, they do it. But sometimes when strategic reasons...
When they want to find excuses to delay to...
You say, so that's the point. So with all of this, I think that the appointment is good. Bafubode is learned, from the 97, there about 96 as a circuit court judge. So it means that he's gone through, apart from the district court, meaning that he's gone through all the courts, circuit court to high court to court of appeal to Supreme Court. So hopefully that would show in his administration. And you see how earlier in the, 2 days ago, he met the Law Society of Ghana, the other umbrella group. And it's good. It's good that we're going to have a second bar association. Yeah, I welcome it. And it's good Bafubode met them and told them, look, go through the law and be recognized. Because we don't want one bar association which will be hijacked by one political party.
Well, that's the point. Others are at the Supreme Court on this matter.
No, he said they should go through.
No, he's adding commentary.
I said that we don't want one bar association which has been hijacked by one political party.
You said.
And it's being used against the other political party. So when there are two, we'll get plurality of voice.
Well, I think the distinction is important.
Yes, it's important so that people don't think he said it.
It will be ridiculous. He can't
say
that.
No, you never know. That's why the distinction is important.
He couldn't have said that. Hey, you create trouble.
Because Oliver and Lama Tipebo are on the same tangent about this connection, as you call it. Are there not enough measures in place to ensure that even if you get to the apex with whatever connections you have, you are whipped in line in whatever you do, so that, like people says, a president will not want to go to bed worrying about
how the
judges would
so they want their lawyer friends.
Are there not structures in place to check that? If you go outside of what is prescribed, you could be petitioned and removed, as we have seen, is it not?
So, I'm going to speak on this from a constitutionalist point of view, and who is interested in constitutional reform. When it comes to the superior courts, high courts, court of appeal, Supreme Court, there's no promotion within that court structure. Every appointment is a fresh appointment. So if you're a high court judge and you're appointed to the court of appeal, you have not been promoted to the court of appeal. You have been appointed to the court of appeal. So it's a different process. Now, who makes the appointment? The ultimate buck stops at the presidency. The Judicial Council can get involved and make recommendations. That's fine. But the truth is that the Supreme Court itself has recognized in GBA versus Attorney General that the ultimate decision is the president who makes it. When the president decided that he was not going to appoint Bensa Bonsu and appointed Puaman, he made that decision on his own without whatever recommendations you have given to him. So the truth is, the considerations that go into why the president will make that decision, presuming that you have met the basic constitutional qualification, that you have integrity and you have made 15 years at the bar, that decision is unimpeachable. If the president can do it for whatever reasons, he can do it as to whether or not he perceives your line of thinking and reasoning to be opposed to his political philosophy and for which reason he wants dissent on the bench, he can do that. If he thinks that, looking at how your judicial thinking is, we are more comfortable with you, he's entitled to do that. the former Supreme Court Justice Atuguba has made it clear that, but this is exactly what we want, that the president will be making a decision. So anybody who is appointed, we must presume that this is somebody that the party and the presidency is comfortable with. And we must live with that choice that we have made, or we must reform it. So that's kind of my thinking around this. But that does not discount the fact that, you know, Chief Justice, potential Chief Justice Bafoboni is stepping into a role in which, from at least the little we have said here, we can tell that there's so much problems within the judicial system. It is not fit for purpose in delivering the justice that we require. It is not, in nowhere close. Even, and I have talked about even the corruption within the judicial service itself. One of the things when I started the law firm was that I told my staff, we're not going to pay any bailiff to go and serve a process. Then it means that my clients will all leave me, because none of your processes will be served. We're routinely paying people to go and serve a process for you. That is unconscionable.
After paying legal fees.
After paying legal fees. It's unconscionable. Now, to determine whether or not somebody has filed something, you have to write a letter, you have to go to the registry, go and pay, search, wait for days, to determine whether or not the person has even entered appearance. How can I not have a system when I say that, okay, this is there, the person has already entered appearance? So there's so much.
The system is there, they are not using it.
It is such a system that I don't understand what we have created. I don't get it. So the job for
leave it and come and teach.
So
somebody should fix it.
I don't get it.
Somebody should come and fix it.
So there's so much problems across board that only a reform-minded Chief Justice can get us where we need to go. He has a few years when he comes in to be able to take us there. And by some strange reason of coincidence, he is head of our judiciary and his wife is head of the prison service. These are key institutions in our criminal and our justice system. So how they plan reform from home and come and deliver it to the public, they have to figure out how we get it. But because we are in such a, let's not mince words about it, we are in a mess. It's a complete mess. So many of the problems we have, our ability to restrict public officers, our ability to get the executive to conform, a lot of it deals with our inability to get anything done with the court system. Nothing.
The whole country down.
I'll give you an example. I have been representing individuals that were deported from the US. In the US system, the names of these individuals is a way in which you can anonymize it. We don't have any of that procedure here. You must disclose who the applicant is. To file a lawsuit, you must disclose your private residential address. What is the privacy concerns around that? When you have an emergency application that you are supposed to make, and when I say emergency, not every emergency must be ex parte. Sometimes it must be on notice. You have to be able to file it for the agents to respond. The US, they have it. Everybody's responding immediately. The judge can take it by video in their home, wherever. We don't have any process. This is why the police can wait. When we have notified them for 3 months to go on a protest, the night before they go and file a process, and you tell me that you must wait for another 3 days to go. It's a mess across board. So I don't know who is like, there's no design thinking, systems thinking in terms of how we administer the judiciary. And then when there's no justice, then we all come and complain, then we go and vote again. And new people will come to tell us to give us the same thing. But the systems element stays the same. And nothing is going anywhere. So for me, those are the critical things I want the Chief Justice to be judged on. And hopefully we see real momentum on that, you know?
And that's a system is inheriting. But then again, how many years does he have to stay as Chief Justice?
Oh, a lot can be done in a year. A lot can be done in reforms in a year.
Next year.
You know,
That's a little over a year.
a lot can be done in terms of reforming the
Let's be
system.
clear, not much can be done in this country in 1 year trying to move around a ship like the judicial service. It is not difficult, it's not equal to impossible. All right? If they get a crazy guy in that place, he will insist that in 6 months, that multi-million-dollar IT system that we have put in place be used. Some of the things Oliver is saying, they sound crazy, but there's no reason why we don't have it. Look, we had to even amend our LI, okay, to allow electronic service. I have been saying for at least 5 years now that there should be a system by which once a lawyer gets onto the file, that lawyer will be served by email. And the system we have now, it is possible for you to be able to check these things in your office. They simply won't use it. The problem in our judicial system is the judicial service. It's not just even the judges and the lawyers. The service, like you said, the bailiffs. You pay filing fees, you still have to pay a bailiff, then you have to follow up. You want to do a simple search. and it's a mess, something that you should be able to do on a computer. We can go on and on and on and on. But my point is, it would take strong men standing up, and this is not a matter of law, it's a matter of administration, okay, and executive management, to say that, look, this system must work because we've spent the money on it. Look, for instance, transcription. We spent money on microphones, equipment, and all those things. Simple maintenance, okay? In a short while, in a matter of months, they were all shoved aside. We go to court, we stand there, and you should be speaking while somebody is typing. The person who is typing is not the lawyer. Sometimes you use legal terms, and you have to repeat it 2, 3, 4 times. It's not their fault, okay? That thing even messes with your mind, all right? There's no reason why it should be so. When today, there is very cheap software. In fact, some of it can be on your phone. By the time you finish AI, it will summarize, give you all the key points and everything. Years ago, outside, I will mention, you go to court today, all right? In 24 hours, you receive in your email the full record of the previous court section. There's no reason why we can't have it here today, all right? So those are system issues, and I think they can be dealt with. On the substantive issue of the appointment of the new Chief Justice, look, there is no lawyer who knows what he's talking about who will deny that Justice Bafuboni is extremely experienced and competent for the job. There's no problem there. Okay. Really, my only issue really is that for somebody who has paid his dues this much, his ascent to that place should be glorious. I think that there is a cloud, it's an unfair cloud around it because of the issues around CJ Torkornoo. Okay. And the point is, you know, we sat here and we spoke about the fact. Look, the president has the power under our constitution to remove the CJ. Last week, I think Lawyer Duji sat here and said, somebody said the easiest person to remove in this republic is the Chief Justice because they take a petition and the president likes it. We should fix those things, but that's the law. The point is, CJ Torkornoo, I have seen a press statement, I think from her lawyers, saying that the procedures are not being followed. She has the right to appeal. She has the right to challenge some of the decisions. She has the right to some of the documentation. She has the right to some reports. She has the right to, certain things. Give it to me. Let me know what to do. Let me exhaust, the remedies available to me. And she's screaming and shouting from a certain place. And it looks like nobody's listening to her. It casts a shade over this Chief Justice's ascent to the table. And my view is that for a man like that, there should be no such cloud hanging over him. Why can't we just deal with the issues concerning CJ Torkornoo? All right? She's claiming there are procedural breaches and issues concerning her removal. Let's resolve them and let this man who has earned his place ascend to that place gloriously. So one, I have absolute respect for Justice Bafuboni. He's been there all these years. Who has heard anything about him? All right, and like people are saying, sometimes you expect him to go this way, he'll go that way, not go. And I think he merits that position. In fact, it's a shame that he has so little time left. And these reforms and things, I would have been happy to help him to do it, for instance. But he has this little time. I think the time that he has, he should try and really break some things.
To break something?
Yeah.
Like what?
The system.
Okay.
And I keep saying, the judicial system. You see, it's hardened. All right, and you can't do anything about it. Look, we have paralegals. They go there, they are trying to do filing. They come back and they tell the master, this one, if you are not a lawyer, you can't get anything done. And like we are saying, we've spent millions of dollars on software, okay? They've chosen not to use it, all right? And the judges are stressed, okay? They have to do so much work, all right? And I think that he should just be bold and fix this system. If he needs the help of Oliver and Kwe and whatever it is, we'll all be happy to jump in and do something. So one, it's sad that we are not dealing with the shade and the issues around CJ Torkornoo so that will be cleared and then he can ascend clearly. That's one. Number two, he does have a challenge coming forward. Look, until you know some of the history, people think that, President Mahama has removed one person and he's going to put, his person there. So he will carry that baggage too, and he would have to deal with it. So dealing with the executive is another challenge that he will have. You have a situation where, like I said, the president is becoming imperial because clearly Parliament can't control him.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.